yesterday I filed a regular bail petition. Right. They may be posted tomorrow. My lord. Co-acquised already been granted by
Friday.
Maybe the logic. And we have to mention item number 22 logic. Maybe open for the day logic.
the series available option.
You want it passed over.
Also for the day.
The request of Mr. P. Tilly. Learned counsel for the petitioner, matter is adjourned for a week. It is submitted by the learned APP that the CD call for has been received. CD received to be retained in the next date. List on
8th of June.
no 5th of June.
Lordship.
Item number 21. The city was setting of panel.
21.
2021. Yes,
Series of received.
the request of learned APP matter is adjourned. Enabling her to call for the CD as directed. List the matter again on
On 8th of June also.
not 8th. It will be on 12th. 12th of June.
Lordship, I get to next item number 56. Lordship, I'm praying for adjournment. My senior has some personal difficulty.
Have you informed the other side? PP. You are mentioning on whose behalf?
I'm mentioning on my senior Arch Chakravarti.
At the request of MS, your name?
JP.
MS so the matter stands adjourned for a week.
Lordship, there's an interim.
Interim, if any, will continue till the next date fixed.
Already.
List the matter again on 6th of June.
I recommend some item number 3.
Yes, why item 3? Why are you mentioning now? Wait for your turn. Item 3 will come just now, just wait for your turn.
Daily list for motion PA item 1.
FIR 1, page number 11.
Yes.
So where is the article number 1 to 15 article where it's planned by the informal manner? But accused person was arrested by the sufficient manner. Because my lord, and it's the page number 25, my lord. Page number 25, my lord, there is a serial list, my lord. You got only the 3 articles, my lord, that belongs to the judicial manner, not to articles of the informant manner.
Did you call for the CD?
Yes, yes.
Heard Mr.
Yes.
S. Roman, learned counsel for the petition, and MS. SH Bora, learned APP for the state. Let the CD be called for.
9th of June also.
List on 9th of June.
Maybe 15, my lord.
No, 5th. I think we have too many matters. 9th. Let it be on 9th. 9th of June.
Item number 2.
Make this lordship.
Yes.
Is the portal in an application, the allegation against me under section 341, 326 and 307. Lordship has given the FIR is based to marriage.
Yes.
A record stated on 34/2023 Sunday that around 10:15 in the night, IC Jyotish Dubey was assaulted many times by Sri Rampu Ali with a sharp weapon due to which a lot of blood has oozed out. The boy had tried to kill me on previous occasions and had also written me that there is law in his residence. In the meantime, I was medically treated with the Hatia of PH in the GMC. Hence, I only claim for you that the appropriate action will be taken against the boy. It is registered under section 341 K26 Then also the kindly claims page 15, which is the providing report. In the forwarding report, your lordship, may I read? I had the honor to forward the following accused person who has been arrested in connection with the appropriate case. They failed to keep him in jail hazard to enable me to complete the investigation of the case. Then I'm coming to the brief, your lordship. The arrested accused person, the FIR name accused, during the course of investigation, one sharp knife has been recovered and seized from the person by arrested accused person. During the course of investigation, the accused person will caught red-handed from the spot. During the course of investigation, sufficient evidence and witness have been found against the arrested accused person. The arrestee admitted his involvement in this case. It is true, your lordship, that there was a fight between the informant and the accused, your lordship. They were drunk, they were in a party, but everything has been recovered the night itself. In fact, I also received injury, your lordship.
We will call for the case diary, heard Mr. P. Devi, learned counsel for the petitioner, MSSH for learned APP for the state, call for case diary along with medical report. List, this is coming from
Nothing of this.
RTO, so list on that is 8th of June, okay. Okay, 8th of June.
Deep your lordship.
Item number 59.
Let me go. Case, so acquired the case 11. But plus, case where not. Never go.
Yes.
So, let's say that today there is some so in the morning or at around 8 p.m. the information this persons in a group and one will see long letter X down and etc. area hence forcibly entered into the campus of my residence and variously injured my father-in-law. Namely, Samsulali was stabbing which start open and set fire on my two dwelling houses. As a result of which inside the room across 51 view, along with the wall household items were completely burned down. The accused person instead of allegedly again destroyed rest of the one house is of my relatives, so it was Spider, 3 houses of Tangiwali, 1 house of Mutawali, 3 houses of Nathan. So the accused builder was signed on 3 high blocks and they are behind the block. New acres already released on jail lawsuit, case 22. When after period of the PD lawsuit, it appears that it is simple injury and it is fight between 2 parties in legal fight. Case 23 lawsuit, last period.
Yes.
On a consideration of the letters available in the case, that it appears that the informant side and the petitioner side both had a mutual fight, and from the description of injury available in the case, that it appears that one of the persons from the informant side had received simple injury. Although statement has been made in the FIR that the houses of the informant will be due to us burns, but from the case, that it appears that one inspection being made on the burnt houses, IO has started Indian friends and the burnt house condition and a few one of Bangalore and team, which was later on seen by the police. In the view of the matter.
Okay, heard Mr.
Take on it.
K. Politer and the counsel for the petitioner, MSSH for call for CD along with the injury report. The list on. When can you get it? It is coming from
8th of June.
8th of June.
It's from Nolvari.
Nobody.
Before
8th of June.
I also there. On 3 high he was arrested.
We can try and 6.
6.
Six.
Okay, list on 6.
Item number 3.
Yes, you praying for time?
I want to find.
Okay, the request of Mr. Yu of the matter for a week to complete his instructions. MSSH for is for the respondent's state.
After. Like.
4.
This is petition under 482 for response of NPWA lawsuit. Yesterday lawsuit, the petitioner already arrested lawsuit.
And then. Remove the case. Then what remains? Then we withdraw it. Upon instructions, the learned counsel for the petitioner seeks to withdraw this criminal petition. Does not wish to press the criminal petition. Accordingly, the same is dismissed as not pressed. You apply for regular.
Item number 5.
Yes.
Interposing of the station text number 70 of the standard edition session that's anything out of that sub PS test number minute. 144 of 2022. Can stay.
Yes, 11.
I see minute.
You know, read the FM.
To be respect and answer solution I wish to take. About part 1 year, the someone is having to be busy from 1 year. Is having to with me without my consent. With false promise.
to marry me and in 7 years, dispute my status. The accused number one has maintained husband or previously with me with the promise that he will marry me during the past 1 year. It is mentioned that on 9/8/2023 at about 7 p.m. that number one has taken me to his house to marry me. He planned manner in perspective with September 3 condition was of the accused number one. All of the aforementioned executive statements attacked me and injured me and also dragged me out of the house of the accused number. The affirmative case was registered under case 76 and 5.
Will issue notice. Heard Mr. Lorenzo, the counsel for the petitioner. MSSH Bora, appearing for respondent number one, issue notice, returnable 4 weeks. Since the Leonard FEP appears for the respondent number one, notices are waived, however, fresh extra copies of the petition be furnished. Steps on respondent number two by registered proceeding. Prayer for interim to be considered upon on the returnable date.
Proceeding committee scan copy of the.
Scan copy of the LCR in respect of PRC case number. Sections case number 70 of 2022. Arising out of Chapel PS case number 144 of 2022. The call for by the registry from the Court of Leonard or Court of Additional Session Judge Bilasi.
Item number 6.
Yes, madam.
My lord, it's an application under section 438 of the CRPC. Praying for the grant of.
Where's your FIR?
It's on page 11. One of the brief facts of the case is that one Mrs. Arjuna Khatun, wife of Mukibur Islam, resident of H. Abdullah Sor, PS Dheen, District Nagaon, Assam, lodged in Ejara before the in charge, Dumdumia Police Outpost on 16th March 2020, inter alia alleging that on 10th March 2020, at about 12 p.m. when she was speaking with her daughter, the accused Jahangir Alam.
Charge sheet has been filed.
Yes, yes.
So you go and appear before the court. Why give you privilege of interim bail, anticipatory bail now?
Actually,
Why?
my lord,
You're absconding.
no, actually, my lord, they never try to apprehend the petition, the accused petitioner. This case itself is false and they actually had long pending land related disputes. So on that ground only this case was filed. And which is why later this matter was amicably compromised between both the parties.
Wait, how do you say that? On what basis?
The complainant herself sworn in affidavit, which is in page 23 to 27. That the matter has already been amicably compromised. Actually, prior to this, prior from filing this Ajahar, they had a very big fight. I think 4 to 5 days ago, which is why after that only they filed this Ajahar.
Heard, MS, your name?
A Bora.
A Bora Learned Counsel for the petition, MS. SH Bora, Learned APP for the state. Let the scan copy of the
Case study.
scan copy of the case diary be called for by the registry from the court of CJM.
Plus no. CJM. first.
CJM,
Yes, Lord.
CJM Nogam. In connection with
Connection with,
Dumduma,
policy case number 2943/21.
No, but this is registered in Dumduma. FIR?
Your Lordship, can you turn to page 21, additional session test number 2, normal.
No. Where is the PRC case?
PRC case is there, Lordship, page 21, PRC case number 2943 of the 2021. The first paragraph.
PRC case of 292943 of 2021. Matter be listed after receipt of the scanned copies as called for.
Item number 7.
Wait, please, Lordship. For candidate verification. Service page 14.
Yes.
May. Would respectfully state that on so at hour so at night, the above named it is part of the base of into the game of our house by taking advantage of absence of my husband and helped me by knocking the door of our house loudly. They immediately entered into our house. No sooner I opened the door and created a free light on my neck, and by changing to take my life forcefully take me out into the compound of my house by pulling my hair and pushed me inside a auto car. After keeping me seated inside the car, they set there on huge number of doors of my house. Thereafter, they kidnapped me and taken me by to Mumbai railway station and ordered me on a train by selling me after the state. Thereafter, the accused person confined me into a closed room at Chennai, where the accused person, namely Kohilud Zaman, raped me against my will.
I heard Mr.
And this. Also, I am for the accused number.
MZ Shah. You are for? Learned counsel for the petitioner. All for CD.
Lordship,
Coming from
Lordship, on 15th of June.
list on 15th of June. MSIC Chipora, I guess for the state ADP.
Kindly put it on you. I am the Isha Gaza Lordship. The accused number 1 is the main accused Lordship. And they had now here since 2018 Lordship.
Have it on 12th. Can we have it on 12th?
Lordship, along with 164 statement.
Along with 164 and medical leave.
Lordship,
Item number 8.
This is a full package information. FIR is page 9.
Somebody mentioned about, you are appearing today.
I am for the Lordship.
Yes.
So, my lord, the FIR is page 9. My lord, there are 5 accused in this unique case now.
Mm.
Out of the 5 accused, accused number 1, Apu Madandar already arrested on 12. By the police, and he is under judicial custody. Accused number 2 and 3 are the brothers of the accused number 1, 2 and 3. They are all brothers.
Mm.
Son of Alauddin Mazumdar. My lord, in respect of my lord, the murder of a minor son of 8 years, in respect of the land dispute which was earlier, but now not, it is no dispute because it was settled by the honorable court. So, respectfully informed that the aforementioned accused number 1, 2, 3 and their father have been trying from a long time to dispose and occupy my landed properties and shop from last 20 days. Of the aforementioned accused number 4 and 5 are like Gunda, that is goons type, and accused person used to use the goon for their self-interest. The accused person committed many incidents previously with my mother, wife, and others, and they also lost many cases against me. At last, I lost information before the police informing threat of my life and my family member under section 107 CRPC against the accused person. From the last 2-3 days, the accused person were moving here and there in front of my house where one shop is located. Yesterday, on 11/3/2023, with the help of criminal conspiracy, the accused number 4 and 5 and accused number 1, with the help of sharp dagger, inflicted injury on the backbone of my minor son, namely Ayam Mazlud Boruya, aged about 8 years, while he was playing in front of my house over the side of the government road at about 12:30 noon.
The accused number one fetched hold of my son, arms, and closed his mouth and pushed dagger from his backbone and injured my minor son seriously. By that point of time, myself, wife, and my mother came from the house and tried to escape him from the clutches of the accused number one, out of fear, trying to debut to save my son. During the course of the placing to save my son, the accused person fled away from the place.
Let's call for the CD.
Yes, my lord. My lord, kindly have a look of police, my lord, page 15A.
15A,
My lord, this is a
forwarding
forwarding report by the police to accused.
in respect of.
And
Accused number one.
Who is there, my lord? During interrogation, the accused person admitted his guilt and stated that he murdered the child out of grudge in regard to land dispute.
Hmm.
My lord, the accused
But he did not say whether he did it on his own or with connivance with.
My lord, that kind of question was not posed by the.
Exactly, so therefore we want to see the CD.
I respectfully agree with your lordship, but in the meantime, this.
In the meantime, in view of such previous serious allegations,
Yes, my lord.
may not be proper to give you an interview at this stage. We'll give you a short date.
Yes.
Heard Mr. I. Tavukar, another counsel for the petitioner, and it's S.H. Mora, another technical for the state, Mr. Amich Soikia, appearing for the informant. All for CD, along with postmortem report. NFSL, if any. Laystone,
13th of June, it's from Qatar.
Achar. 13th of June.
A copy of the petition you saw.
Can you serve him a copy?
Yes, I just know I thought.
Yes.
Supplementary list for motion item 60.
Let's be done. Well, in this case, tax is already converted to millet, and the millet tax was from the order taken from this back. And the case of millet, office under kitchen millet, timely deck millet, and also added 376 millet. Below, approves the Lalit Court below millet. Lalit Court below had rejected my application on the ground that I have been so absconded. Please question one is the order of the special order. Special order. And the someone was issued my letter, page 42 my letter, elected time. 10 prepared. As per Supreme Court.
You are the what? You are the husband.
Husband, madam.
Husband.
Yes.
So,
And there is a child also, madam.
so as per Supreme Court order,
Commander, that is anti-50 daily smell at the. We can find that. Then after.
of course you can. Nobody is doubting that. But we'll have to call for the scan copy.
Lakshmi also. In the meantime, my lord.
In the meantime, we cannot go against it.
Because my lord, admittedly, my lord.
You are shown to be an absconder. You are shown to be an absconder.
And out of there, my lord, married, child is also.
Maybe. Heard Mr. G. Uddin, another counsel for the petitioner, Mr. Vivi Gogoi, another AVP for the state. Sent his plenary bail is filed by the petitioner apprehending arrest in connection with Manikpur PS case number 25 of 2023 under section so and so China Marriage Prohibition Act. There with section 6 and 17 of POCSO Act. And section 376 IPC. It is submitted that charge sheet has been filed in the matter and it's presently pending trial. Before
Special judge, my lord, session judge, Mohit.
session special judge Omega.
Mohit. My lord, session case number is also there, page 42, my lord.
Page
42.
42.
Case number is special P 54 within bracket M 2020.
Special case number special P 54M 2023. Let the scan copy of the case be called for by the registry. List the matter immediately upon receipt of the scan copy. Prayer for interim will be considered upon builder scan copy as called for. With
61.
yes, Mr. Pora.
It's 438 application, madam. What happened, madam, there's a dispute between the two group of one Mohila committee, madam. What happened, madam, I have purchased the land from the owner of the particular land that logical file that initially is page 13. This is a deed of sale of that particular land, madam. And that has been registered and that has been executed accordingly. Thereafter, madam, in that particular land, a clubhouse of a Italian Mohila committee, they are also occupying a small portion of the land in the adversely one. The 3 quarters of land for this. Then what happened, madam? There is a negotiation between the club and the me as they are occupying that particular land. And as per that, for the Lordship now currently page 20, the memorandum of understanding being executed between the executive members of the club. And they have agreed to vacate the 2 quarters of land. And I have also agreed mutually out of benevolent manner that I will construct a clubhouse and I'll pay some money also for the construction of the clubhouse. And 1 kata I'll register in their name. That was the MOU signed between the executive committee. Thereupon, when I have tried to take the possession of my particular land, then this FIR has been initiated by the fraction of the club members, implicating the others, but I have been not named in that FIR. That logic will find at page 24.
Yes.
Yeah, I wanted to state that the land possessed by the Italian Mohila committee situated at 20 Narangi Road is sold secretly to Rameshwar Taluka residents of Itanagar for a consideration of 40 lakh by the resident and secretary of the managing county constituted illegally by a few women. According on so and so, the state person came to take over the position of the state land and the local people of to know about this. Sorry. Stop the taking over the position and accordingly today's so and so general meeting is held in presence of all the residents of the area and full and fresh Mohila committee is constituted and to take the organization. Request you to investigate the matter and the matter take the appropriate legal action against the greedy person who wanted to destroy the organization by illegally taking the property.
Who is the informant?
One of the
Member.
of the that particular club, my lord. They have constituted of their own, my lord. There is also complaint to that effect. We have also instituted a civil suit regarding the formation of the new body that is also pending, my lord, before the civil court. This is the page 29. Lordship will find.
But there is no allegation against you. Why are you
Yes.
apprehending?
Because I have purchased the land, now the police is, because I have paid the money to the organization, the Mohila committee, and I am the original owner of the land.
You have paid what money?
I have paid the 40 lakhs, that was in the MOU,
Ah,
for construction and vacating the land, which belongs to me itself.
okay.
That is the delegation, and the delegation is that
No,
the.
it belonged to somebody else from whom you purchased
Yes.
initially.
Annexure 1,
And
I have purchased from.
when was this purchase completed?
The purchase was completed by the logical file, that is the page,
23, May 23.
it starts from page by the 13 onwards. The registered sale is page 11. Original owner from whom I have purchased it.
Hmm.
And there the club minor, Mohila committee, they are encroaching the land actually. Illegally. They have no right title over that property. But because there is a dispute, there is a club is constituted, there is a negotiation of MOU. They have relinquished two parts and I have agreed
Yes.
to.
When the CD come, my lord, and what is short that may be given.
What about anyone for the informant?
My lord, that informant, my lord, club member, I think. They have objection.
Against the others, against not me, man. They have not implicated, but because of the.
There is no prima facie, there is no allegation against the petitioner. Except for the fact that he was
But in the affair, his name, my lord.
no, he's named only as a purchaser.
Yes, yes.
No allegation that he is committed
That
any,
purchase and sale, it was my lord,
nothing like
These
that,
are the prima facie two documents I
that
have.
is civil nature.
are of civil nature. Isn't it? Heard Mr. M. Bora and the senior counsel assisted by Mr. D. Bora. D.P. Bora. Counsels appearing for the petitioner. And Mr. B.P. Gogoi, learned APP for the state. This EP petition is filed by the petitioner, Sri So-and-so, apprehending arrest in connection with an FIR dated where is your FIR? Where is the FIR?
My lord, the apparently page 24.
FIR dated 15/5/2023 lodged by the informant one Srimati Lipika Rajpal. Most of in the state of FIR, it was alleged that the president and secretary of the managing committee of Gitali Mohila Committee, situated at 2 Motuoria Zunarangi Road, has sold land to the petitioner for a consideration of rupees 40 lakhs. Full stop. When the informant came to know about this transaction, the local people who are coming to know stopped taking over the possession. This FIR was received and registered as Nunmati PS case number 144 of 23 under section so-and-so. Learned counsel, senior counsel to the petitioner submits that petitioner has purchased this land from the original owners by way of a deed of sale executed on 2nd of May 2023, copy of which is enclosed. The paid petition as and is available at page 13 onwards. Also, there are party to submitted that there was a memorandum of understanding between the executive committee and between the Mohila committee, Italy Mohila committee, that the petitioner will construct the clubhouse. And he shall pay some of rupees 40 lakhs
And 1 kata of land.
and 1 kata of land. Okay, so it is submitted by the Learned Senior Council that the amount of 40 lakhs has been paid. And the 1 kata of land is also earmarked for construction of the clubhouse. It is submitted that there are no specific allegations against the petitioner in the FIR. However, his name is referred as the purchaser of the land also. Considering the investigation which is carried on in the matter. The petitioner apprehends that he may be arrested and therefore has approached his court. Then having heard the learned counsels, let CD be called for. In the meantime, if the petitioner is arrested, he shall be released on furnishing a bail bond of rupees 30,000 with one local series to like amount to the satisfaction of the arresting authority, subject to the following conditions. Petitioner will appear before the IO within 10 days from today. Petitioner will not hamper, impede with or interfere with the
Not fair, but he's undergoing some treatment. Can it take 15 days? Very quickly.
he is out of Guwahati.
Yes. Yes, yes, he's undergoing treatment at Apollo Delhi minor. He started here. Within 15 days.
Make it 10 days. We normally give 1 week, but in your case, we are giving it 10 days.
12 days.
Make it 10 days, tell your client to come and appear.
So we'll have a time sample.
He has to appear, and then with the permission, he can go for the treatment, if required, if permitted. He shall not move away from the jurisdiction of the so-and-so police station without written permission. The court. Any of the conditions found to be violated, the IO will be at liberty to pray for recall, cancellation of the interim bail granted. List on 26th June.
Problem.
Daily list for admission, item 9.
This matter will be taken up at 2 p.m.
Why?
Senior is the number 1. So the last communication, my lord, we are in leave, that's why
You are in?
last communication, there even unrepresented. We are in leave, my lord. We went to my seniors medical.
Who is your senior?
SB Lucknow. Last communication.
All right, at 2. At 2. Then let it be on Friday.
Let it be a 2, my lord. There is another matter. Possible accommodation for self-implement.
You try to be here at 2.
My lord.
Yes.
Item number 10.
This matter will be taken up at something.
At 2.
Eleven.
I take for the response number 2, let's say. So, let's say, I may be allowed to file an affidavit regarding this petition.
Hmm?
I may be allowed to file it. I mean, for so to spend number 2 years.
Your name?
Next,
NH
plus,
Law School. The Learned Counsel, Mr. NH Law School, appearing for sole respondent. Respondent number 2,
number 2.
prays for a short date to file objections. Mr.
AM time.
Here,
AM time.
AM Khan appears for the petitioner. And Mr. P.D. Gogoi for the states. Let the matter be listed after 2 weeks. Enabling Mr. Learned Counsel for the respondent number 2 to file their objections. As per
Interim order part 30.
interim order parts earlier will continue.
First to this point.
12.
একটু এবার অপরাজিতা ডিক্লেমেশন করে দিই। হুম।
2 weeks time maybe allowed to reply.
Huh? For filing reply.
My lord. That's why it's
As Dr. Senior Advocate.
no, my lord, it's to be proven.
Okay, good. It is submitted that Mr. S. Doctor appears on behalf of the respondent number 2 And some time is prayed for to enable the respondent number 2 to file the objections to the matter. Learned counsel for the petitioner has no objection. Accordingly, let the matter be listed after 2 weeks, enabling them to file the objections. Mr. B.D. Gogoi appears for the state, Mr. Bakshi appears for the petitioner. Interim order passed earlier, we continue till the next day. Itu udah kawan. Udah like already.
Item 13.
In this case, I have got the white lordship. I made a mention for listing of this matter as lordship, the husband did not pay any amount. Maintenance.
There is an interim order.
No, madam.
There was no interim order. In fact, there was an order of this court, you go and pay, and after that, bring the certified copy of that order, and thereafter will hear your petition.
Which order?
It's maybe 26/9/2022. Petitioner to take instruction 26/9/2020. Or before that. Lordship 5/8/2022.
Yes.
Madam, there. The previously there, madam, the petitioner is ticket not service.
There is an order,
Melody.
judicial order.
Yes. Which the lot is there. Madam, he is ready to give madam, but if you not settlement, the pensioner against madam, he.
No, all this will not do. We are giving you 2 weeks further time to comply with the order dated 5/8/2022. Petitioner is permitted further 2 weeks time to complete his, to furnish proof of payment of maintenance to the respondent. In compliance of the earlier order dated 5/8/2022. Passed by this court. List the matter after 2 weeks. MS R. Chaudhary appears for the respondent number 2. And okay, sole respondent.
Right.
List after 2 weeks.
Lordship, can it be listed on 7th or 8th, lordship, anything?
12th of June.
Make it clear.
Correct.
Item number 18.
2 weeks over.
Item number 18.
What is it? Yes.
Here also I am paying for custody of a vehicle lordship. The vehicle was seized on 9 of August 2022. Since then it has been in custody of the police. And 2 tires of the vehicle have already been damaged. As per my information. Petitioner is the registered owner of the fixed car. And annexed the registration certificate. At page.
Yes, madam.
Lordship, so we require the police report in this case. Whether. this is very-
Where is it?
matter.
Where is the vehicle?
It is at the Limo police station.
You get a police report.
Lordship,
Lordship, that police report, if the lordship was the earlier order, the case diary was retained, was directly retained, for signature.
in that regard, I don't have any instruction right now. Lordship, we try to fix us a date.
There was a direction already
No,
for a police report.
Yes. This petition is pending for more than a year.
Let a police report be, let a report from the investigating officer be called for in respect of the vehicle, which is stated to the vehicle of the petitioner stated to have been seized. Full stop. The report be placed before this court by the next date fixed. Mr. R. Bora appears for the petitioner, MSSH Bora, APP for the state. List on
Lordship, 12th of June,
But it's too long. Petition is pending for the 4 months.
9th of June.
Can it be on next week? Because already 2 tires have gone, Lordship. Now the remaining 2 tires are there.
your matter has been pending from March.
Yes, Lordship. March, April, May.
Then
And the vehicle was seized on 9th of August.
there was a direction to retain the case diary also.
Yes, Lordship. That is why.
It's for-
So in that regard, I don't have any instruction right now, Lordship, but kindly fix on 5th of June.
5th of June, okay.
Lordship,
Not 2 weeks, let it be listed on 5th of June.
organized.
Bail hearing item 19.
Yes.
Let's check the petitioner was arrested on 20. 12/6/2021. Subsequently charged with threat to evidence is yet to be heard. Is very critical. Filed in the month of January or February. And LCR has received pursuant to the court's order.
Do you want to go through the LCR?
Yes, I have gone through, Lordship.
Yeah, you have.
After studying, charge has been framed, Lordship.
Mm.
Until date, Lordship, trial proceeding is yet to be initiated.
Right. When was the charge sheet filed?
Was filed on lordship. Plus information, 24/9/21.
Imagine.
It was posted last year on 1/3/2023 for evidence, Lordship.
Hmm.
And thereafter, I have not found any records
Evidence.
regarding the depositions of the prosecution witnesses. Lordship, give us a sorted and call for the status report, whether any evidence is
There is no
based or not. that we do not know.
expecting that up to that, status report has been received.
Yeah.
Last office meeting there. Just prior to it, 22nd.
Nothing to comment on the evidence. Evidence part, we have not found nothing in my management, also gone through it.
Once
And we have to check it out.
other teacher's accidental, everything is there, evidence, well, it is not. Comment, because
Yes,
for last, more than 1 year, it was again and again for evidence.
Call for status report in respect of examination of the witnesses in connection with Sessions case number 54 within bracket DH 2021 under section so and so pending before section judge Hemani. Let the matter be listed again. On 5th of June.
Lordship,
No, let. Call for registry to call for. Registry to call.
Item number 20.
My lord, 68 days I in custody as on date of.
Hmm. CD received.
Should be received.
Where is the FIR?
It is 8 of.
Age?
8 days.
8.
Very short I can.
Hmm. Yes.
Is that there is a boundary dispute between the accused number 2 and the informant. And the petitioner is accused number one with the relative of accused number two loss.
Hmm.
Earlier, there was the tussle between the accused number two and the informant family. The accused petitioner number intervened the tussle, therefore he is dead into this case. This is the main.
How many petitioners?
One petitioner,
Here, one petitioner.
accused two.
What happened to the other accused? They are arrested.
No, he's not yet. Fine.
When did the incident occur?
It has alleged on 25/9/2022.
25/9. What is the name of the petitioner?
Maybe or no.
There is material against you. Now, why is it taking so long for filing of charge sheet?
Who it was yet to be.
Perhaps the information is implicated in our statement. That will definitely do because he filed FIR. So
Not only that, but the allegations are serious, although medical is, there's no.
She is married woman, let's say.
Mm,
My humble submission is that there is no implication of medical report in this case. She is married.
Yes, Mr. APP.
67 days or 68 days. Length of
7 days, all right, but it was yet to be apprehended. And material is there in the diary. 164 statement clearly stated his name.
If you apprehend the accused number 2, he is in detention 68 days.
I don't think it is a good. There are materials against you. Serious materials.
68 days. The length of detention.
No, length of detention, okay, but there are police is. The investigation is carried on. And there are other people at large.
What another people is there, accused number 2. He is said to be apprehended to my information. What my line is suggesting here. Action may be taken against him also. And if he is not arrested, it does not mean that I will not be.
Okay, heard, Mr.
Am
I Hussain, learned counsel for the petitioner, I was maybe APP for it. Learned APP for the state, this every petition is filed by the petitioner. Apprehending arrest, this bail petition is filed by the petitioner seeking bail as he was arrested in connection with an FIR dated 27/09/2022, lodged by one Nur Begum is the informant also. In the said FIR, it was alleged that on 25/9/2022, the accused person's name in the FIR, including the petitioner, had entered her house and committed gang rape by gagging her mouth. Also, pursuant to the investigation being initiated in connection with the same matter, the petitioner was arrested on 18/3/2023. Also, the CD was called on by this court, and which is being presented by the Learned APP. Also, perusal of the CD reveals that the informant has implicated both the accused, including the petitioner, in her statement made under section 164 of CRPC. Also, the medical report, however, does not reveal that the informant was exposed to physical relationship. Also, perusal of the CD reveals that the matter is still under investigation and some other accused persons have not been arrested. Also, statements of various witnesses perusal of the statements of other witnesses reveal that the allegation of the informant is corroborated also. Considering the incriminating materials available in the case diary, this court did not find it a fit case to enlarge the petitioner on bail at this stage of investigation. The petition is according to dismissed. The CD is written.
Item 23,
23 diary not neglected. Here petitioner will be custody for 56 days from the date of production. And it is under 56A. FIR is page number 8.
Why is CD not received?
So just here, madam.
Nearby, not very far. When can you get it?
I got 7, 6.
Already 56 days, and then 60 days period will be appointment. And when victim is recovered,
And
nothing there, whether
today is how many days?
56 days from the date of
56.
date of arrangement, 57 days.
Let it be on 12th. Sorry, let it be on 29th.
29.
Call for CD, fixed on 29th.
bail hearing AB, item number 25.
CD,
CDDC.
This case must kindly come to the affair. This 9 is the affair. Here we got the 8 persons name mentioning the affair as accused man. And it is a important time. Respectfully, basically stated. The accused number 1 last me since 3 months, and he used to call me over phone number console and chat and talk to me of law. On 29/8/2021, at about 10 AM, while I was going from my house to Mayabari Hospital, I reached on the road of Vartal Tulai of Kalbart. The accused number 1 and 2, coming by motorcycle, forcefully kidnapped me. The aforesaid accused person, after kidnapping, took me to Bhelaguri Gaon and kept me in the house of a person of village Bhelaguri. And night at about 12 PM, the named accused person, along with 3 unknown accused persons, total 11 persons, committed rape upon me. When I raised huge cry, then above named accused person, taking sword in their hands and showing sword at my mouth and threatened me with dire consequences. Shopkeeper of Bhelaguri Bazaar, namely, this is important line, Ahidul Haq, along with his brother, saved my life from the place of offense. The accused person kept me in the night, and on next day morning at about 6 AM, the accused number 4 by motorcycle left me on the road of Bhelaguri. Now the accused number 8, resident of Vartal Tulai, by inducement prevented me from closing the affair. He stated that 11 persons committed rape, and night one person's name is mentioned here, Ahidul Haq, is a shopkeeper of that market, and Ahidul's brother. These 2 persons saved her life. Again, she said that in the morning, the accused persons thrown off her. So there is a contradiction. If she was said
this is an FIR. This is an FIR.
yes, ma'am. And
It is not a deposition.
kindly examine the government 11 persons saying that committed rape. The present prisoners name in the affair, serial number 5. DJ portal news reporter of Pratibimba Life of the locality. Very unfortunate manner. Kindly examine such type of affairs that 11 persons.
So why these FIR is lodged? What? Why? What is the reason?
Saying that she has law affair with the accused number 1. If I would also say in the affair that some news was in his hand regarding this relation. Kindly examine the medical report as well as the statement of that person herself saying that Ahidul Haq saved her life. If saved her life again, next morning, how she will rescue from the accused person.
Medical is done after 2 months. What will it reveal?
Not the serious case, my lord. If 11 person commits such kind of offense, my lord, without admitting in the hospital, it's not possible, man. It is unbelievable, my lord, this story, man. Because she clearly stated that they commit the offense, not saying that right. Why she did not go to the hospital? But so many judgment also the honorable court, my lord, that
Show us.
asks us, my lord, one judgment, my lord, in the case of. Can you go? So in this case, my lord, the managed transport, my lord, equities, the accused person on the ground of medical report in the gallery. And High Court, my lord, again commented, the Honorable Supreme Court, my lord, takes.
तो कोर्ट चलता है ना, तो आप लोग यहाँ मत आइए, वहाँ जाइए।
And delay of closing the affair also not properly explained.
What is the name of the petitioner?
One of the previous one, LIC here.
You are implicated.
May I just change the name, my lord, I think the investigation will be top, my lord. How is it going? Because some persons behind the case, my lord. On their dictation, the affair was lost. Now, the case of rare gangrene, medical was examined after 2 months. But only that plea, my lord, he cannot establish that case, my lord.
Yes, Mr. Gogoi.
But the investigation is might have going on. And
Yeah, why medical after 2 months in a case of such serious allegation?
yes, that is true, my lord. But that is up to investigation.
Then why do we not pull up the investigating officer?
Is a
In an allegation of this nature, the victim is put up after 2 months.
This type of serious case,
Huh?
they should immediately send to the hospital, my lord, that victim.
Yes.
Into other, page 51. Regarding negotiable instrument act, my lordship, 130.
Hmm.
51 is the page.
Yes. What is it listed from today?
But the order was it took pay of 5 lakh in court of interest 6 months, which has been special performed. But this matter is as the party.
So this case listed today for admission.
Hmm.
Initially, there are the concurrent findings of the court below. The Lana prior to convicted the petitioner, and thereafter appellate
The
court
court
uphold the
of-
order.
Court of SDJM first.
Yes, ma'am.
What was the finding in the court of verification?
And the state amount was for a pool of 97,000 and 99,000 each, 3 checks were there.
Hmm.
5 lakhs was the compensation amount.
Hmm.
Thereafter, along with 6 months, the simple imprisonment in default. Defaulter clause is there. And thereafter, appellate court affirmed the judgment, conviction.
Hmm.
Now, there is a provision of revision. Instead of opting the revision, he has filed this under 482. That is also one of the maintainability regarding the question of maintainability.
Because I have submitted one judgment, my learned friend wanted to file affidavit in opposition. In that regard, it took time, to file.
No, I never took time. He is there,
Affidavit in opposition. I submitted one.
Immediately I submitted that when there is an alternative remedy,
Judgment of honorable effect.
yes, let me submit. You have submitted, let me submit. So, I have submitted that when there is an alternative remedy, 482 cannot be, you cannot take result of the 482. Alternative remedy, there is no appeal. If no appeal, the revision lies. So he, instead of going for the revision, he filed his 482. I have submitted
Revision before which court?
High Court.
Convert it if required.
Yes, earlier I have submitted a judgment of the division bench of Honorable Supreme Court. Thereafter, he submitted an judgment, full bench of the Honorable Supreme Court. So, that judgment, perhaps, my learned friend, some line in this, I have submitted that when there are alternative remedies, revision not right. But there is a rider, if you find the judgment of my learned friend submitted, Prabhu Saula, Prabhu Saula Lordship will come to the next second page. Second page, then Lordship will down below, from the paragraph 10,
Yes, yes.
The first question is to whether the inherent power of the High Court under section 482 stands repealed when the revisional power under section 397 overlaps. The opening word of section 482 contradicts this contention because nothing of the code, not even the 397, can affect the amplitude of the inherent power reserved in so many terms by the language of section 482. Even so, a general principle pervades this branch of law when a specific provision is made. Easy resort to inherent power is not right except under compelling circumstances. Not that there is absence of jurisdiction, but that inherent power should not invade areas set apart for specific power under the same code. In Madhulimai versus State of Maharashtra, this code has exclusively and if may say so with great respect, correctly discussed and delineated the law beyond mistake. While it is true that section 482 is pervasive, it should not subvert legal interdicts written into the same code. Such, for instance, in section 397(2), apparent conflict may arise in some situations between the two provisions, and the happy solution would be to say that the bar provided in subsection 2 of section 397 operates only in exercise of the revisional power of the High Court, meaning thereby that the High Court will have no power of revision in relation to any interlocutory order. Then, in accordance with one or the other principle enunciated above, the inherent powers will come into play. There being no other provision in the code for redress the grievance of the aggrieved party. But then, if the order essayed is purely as an interlocutory character, what should be corrected? What could be corrected in exercise of the revisional power of High Court under the 1898 code? The High Court will refuse to exercise the inherent power. But in case the impugned order clearly brings about a situation which is an abuse of the process of the court or of the purpose for securing the ends of justice, inference by the High Court is absolutely necessary. So, when there is abuse of process and
in ends of justice demands, my lord, then nothing contained in section 397(2) can limit or affect the exercise of the inherent power by the High Court. But such case would be few and far between. The High Court must exercise the inherent power very sparingly. One such case would be the desirability of the quashing of a criminal proceeding initiated illegally, vexatiously, or as being without jurisdiction. In short, there is no total ban on the exercise of inherent power where abuse of process of the court or other extraordinary situation exceeds the court's jurisdiction. The limitation is self-restraint, nothing more. The policy of the law is clear. An interlocutory order, pure and simple, could not be taken up to the High Court, resulting in unnecessary litigation and delay. At the other extreme, final orders are clearly capable of being considered in exercise of inherent power. If glaring injustice stares the court in face, in between is a terracium with an unfair justice, as pointed out, as for example, where it is more than a purely interlocutory order and less than a final disposal. The present case fall under the category where the accused complain of harassment to the court's process. Can we state that in this third category of the inherent power can be exercised? In other words, justice so and so.
What is the judgment of referred here? Some tobacco, Dhariwal tobacco. What is the judgment here?
So here, my lord, Honorable Supreme Court held that.
No, you're right, but it has referred to the earlier judgment also.
My lord,
Come to the last page, second last paragraph.
Yes, in our considered opinion, my lord,
Hmm.
in our considered opinion, the learned single judge of High Court should have followed the law laid down by the court in the case of Dhariwal Tobacco Products Limited Chopra and the other earlier cases, which were cited but wrongly ignored them. My lord, earlier, my lord, I have cited, my lord, two more judgments. Those are, my lord, the division bench judgment, my lord. In that judgment, it is clearly stated that when there is alternative remedy, it cannot be, my lord, it cannot be invoked. I may allow to stop it again, my lord.
ये judgment निकालो. Note करो.
So you will find
तो judgment मतलब
1999, my lord, 6 SCC 146,
Hmm.
page 146. I submitted earlier.
1990.
1999, my lord. Volume 6, Supreme Court cases, 146 page.
This is with in respect of what?
In respect of that, when there are alternative remedy, my lord, 482 cannot be invoked. I will be allowed to the relevant portion of it.
Let us get the judgment.
But
Mr. Counsel, what do you say? What do you say with regard to the judgment cited at the time?
It is not an interlocutory order. This judgment, honorable judge held that it is decision of the court whether to entertain or not.
No, discretion. When the court notices, it is required to secure the ends of justice.
Yes, my lord. If I have filed, if the court, I can satisfy that interference of court is needed, then only my case will stand.
That's right.
Otherwise, it will not stand. And moreover, my lord, divisional jurisdiction also a discretional jurisdiction. I cannot, as a right, I cannot claim the honorable court to interfere. In case of appeal, my lord, it is my
No,
right.
he is urging the point of alternative remedy.
Yes.
First, you'll have to cross that hurdle.
Yes.
In the face of the judgment given by the relied upon by the Learned Counsel.
Yes. I have submitted this full bench judgment, my lord. And my submission is that in divisional jurisdiction of the discretionary power, in inherent jurisdiction of the discretionary power, as a matter of right, my lord, I cannot file this petition. And
Only if the honorable court sees that interference is needed, then only my lord may takes that.
SCC to fully local. Okay.
Otherwise, second appeal, my lord, I have preferred appeal, that has been dismissed. For the ends of justice, my lord, I have taken a ground that for the ends of justice, I have filed this petition.
What are your grounds?
My ground is that, my lordship, the respondent, my lordship, he took the plea that I have given him 3 checks, my lordship, of equal amount, 99,000 each on the similar day, my lordship, for the same year. And I borrowed rupees 3 lakhs from him. My contention is that, my lordship, I never borrowed any amount from him in his cross, my lordship, because he cannot exactly state on which day I borrowed them. The honor,
Why did you issue the checks?
my lordship, I issued, my case is that I have issued the checks as security deposit, my lordship, because there was the agreement between him and me.
And
That-
regarding,
For regarding taking loan, and he requested me to give 3 checks as security deposit, blank checks.
Hmm.
So I gave him 3 blank checks. And it can be very much, it is apparent on the checks itself, my lordship, you can see the check, my lordship, on page. Page 22, my lordship.
Hmm.
This is 3 checks, my lordship. My signature, my lordship, Chiraspi Pal, there it is, same date, 3 checks, my lordship.
Hmm.
If I would have given check of 3 lakhs, I would have given 1 check of 3 lakhs, my lordship. Here he has presented 3 checks, 99,000 each.
You say that these are not your checks.
My check, signature is mine, but I have given him blank checks because there was this.
Why did you give him blank checks?
Because he used to work in a bank, my lordship. He wants to, he is a representative, my lordship, and he told me that he will arrange a loan for me, so I have to give blank check as a security deposit. My lordship.
Security,
In the cross,
security for what amount?
for the loan amount.
What is the loan amount?
He could not sanction that loan, my lordship, from the bank. His cross may be seen, my lordship. Cross is on page, my lordship. Page 6, my lordship. Page, my lordship, page 31, page 31. Page 30.
Yes.
May I read, my lordship?
Hmm.
I can't say on which dates in the month of October and November the accused has taken an amount of 3 lakhs. His argument is that I have taken 3 lakhs loan. He can't say the date and month of October and November from me with the condition to return the money with interest within a year. It is a fact that there was no written agreement in respect of borrowing money by the accused. Accused collected the said money from my PCO booth situated near the railway station, Brahma Temple of Lamdi, in my written evidence as well as in complaint. I have not mentioned the fact that accused collected the said money from my PCO. It is a fact that on which particular dates I demanded the amount from the accused. I have not mentioned in written evidence as well as in the complaint. The stipulated time to return the borrowed money has been completed immediately after October and November 2012. But the exact date of expiry of stipulated period, as per the terms and conditions, I can't say. Accused handed over the checks in my PCO. It is a fact that I have not mentioned in my written evidence that checks were given in my PCO. As per instruction of the accused, I deposited the checks in SBI Bank for second time on 21/10/2013. Thereafter, when the checks were returned without encashment due to having an insufficient fund, I inquired about the matter and again presented the checks in bank for second time as per instruction of the accused. So I have, before filing this case, my lord, I have also filed complaint case against him that that complaint is my lord. I have referred also. My lordship, humble main part of my submission is that I have never borrowed any money from it. And the negotiable instrument act 138, loan is necessary, my lordship, borrowing of money is necessary. On the basis of only checks, my lord, it is not absolute liability, my lord. That only my signature is present on the check, then I should be liable. We should prove borrowing of money. And 3 checks, same date, my lordship. Had I given him any check, my lord, I would have issued 1 check of 3 lakh rupees.
Let us go through the judgments in the first court.
My lord, first judgment is on page 14, my lord.
The LCR has been called for. LCR ऐसे नहीं है. No. 10 rupees. Yes.
Points of determination, page 42, my lord, whether the accused Timothy Chiraspi Pal had issued the above mentioned check 5/9/2013, loan on SBI Bank of India, London, for 99,000 each only in favor of the complainant in discharge of legally enforceable liability. That is, I have accepting. I have.
No, if you accept
my
that,
lord.
then it is a
Not
case of
for
you
loan,
issue.
my lordship. I am accepting that signature is mine, but there is no loan, there is no liability, my lordship. Those checks, these checks were, blank checks were presented for as a security, my lordship, which he promised that he will arrange a loan from me. I have in my written statement also, I have stated upon my submission. my lord. Because he used to work on for giving loan, my lordship, in behalf of different banks, my lordship. He promised that he will arrange it because at that point of time, my sister's marriage was there. So I wanted a loan. So I presented him the blank check so that he can arrange a loan from.
But once you present a check, there is a presumption that you are
Yes,
issuing the check.
in my favor, my lordship.
How
It
will
will
it
be
be?
in his favor,
Uh-huh.
but he should, for liability under negotiable instrument act, my lordship, there must be some loan, my lordship. That is not
That
absolute.
is the presumption that you have taken a loan and you are required to pay, therefore you have given the check.
He cannot state, my lordship, on which day he has.
Date may not be relevant, but he has made a statement, he has taken it.
Yes, he has.
He does not deny that no loan was taken. Where is that cross?
Yes, my lord. It cost page 31. And in those checks, my lord, only signature is mine. Handwritten, other things are not my handwriting. I have also filed complaint case number CR 540/2014, my lordship, against him. That he deposited, he cheated me, he did not give me any loan and submitted those checks before for encashing. Page 36, paragraph 5, my lordship, of my ground, of my affidavit in chief, my lord. Annexure 5, page 35. Annexure 5, page 36, para 5.
Yes,
That I, the deponent, never wrote any amount on 3 checks. I signed and gave blank checks for departmental loan, but I only gave blank checks to the complainant. The complainant,
what is the departmental loan?
that I don't know, in the statement is written there.
You are employed somewhere.
Yes, my lord, in railway, my lord. The complainant himself wrote rupees 99,000 on each of the checks and by depositing the same in bank.
Where are the papers? Departmental will come to para 2.
Yes.
You get signed on some various papers.
Where
Where are the signed papers? Was it produced before the court in evidence?
Yes, my lord, this is the evidence in chief. He has not. And in this regard, I filed complaint case number here, I totally oblique 2004.
No, that is okay, but the presumption is against you. Do you have any authority to cite that?
But generally, whenever one goes to get a loan from bank or.
He's not, he's an employee of the bank.
My lord, he is not an employee of the bank, so far from the statement I able to know. But there are few persons who work as a listening officer of the bank, my lordship, who have good relationship with the bank.
But the person in his clause has stated that you have taken a loan of 3 lakhs.
Yeah.
With the condition to return.
Yeah, my lordship, if a person gives me 3 lakhs, you would at least remember the date on which he has given.
He may not have, that is a minor.
It is not a 10,000.
When-
5,000 rupees, my lord.
When was it given? According to you, when was it?
Interest also, he selling which for the. interest,
According to you, when was the loan taken? Or when did you issue the check?
My lord. The complainant could be about W409, the 492,000, paragraph 3 may be seen, my lord.
Para
The
3.
paragraph of the Alexa 5, page 35. This is my deposition, my lordship. All the facts from my part, my lordship, these are the facts. That I am a government para 2, my lordship. Page 35.
This was discarded, but because he was not cross-examined, he did not appear, so discarded. Now. This one. DW, there is no DW.
Yes.
That I am a government servant working in the Department of Railway. The complainant being a known person visits my office. The complainant took my signature from various departments with a promise to procure departmental loan for me. That thing I also could not understand what is departmental loan.
You can't understand your client's instruction. What is this?
Departmental loan, what?
You get your instruction.
My instruction is that he used to work as a listening officer with, he has a connection with different banks. And he used to arrange loan from different banks with the manager he has connection. So he promised her that he will arrange it, because at that time her sister's marriage was to happen. I signed on those papers on good faith. After a few days, he informed me that rupees 20,000 was required to be paid to the bank. And as such, I paid rupees 20,000 to him. Paragraph 3, that the complainant called me over phone on 492,000.
No, Mr. Counsel, you are harping on the facts. There are 2 things you must satisfy the court. Number 1, that you point out something in the judgment that it requires the court to interfere or allow your petition
My only.
for the cause of justice, for securing the ends of justice. Number 1. Number 2. Number two, there is a presumption in your favor
Yes, ma'am.
against you. How do you want to disclose it?
Point of determination, the issue has been framed, my lord, 4 issues has been framed.
Hmm.
In those issues, my lordship, one issue that whether there is a loan, whether the petitioner, whether the petitioners taken any loan from the respondent, that issue was not framed. One issue is that whether the accused Srimati Chirithupal had issued the above mentioned text on 5/9/2000.
The point number 1 itself
Yes.
includes that whether you have issued the checks in discharge of a legally enforceable debt.
I have issued check, but it was not issued for legally enforceable debt.
You show us some authority.
for a liability.
Then what is a legally enforceable debt in so far
There must be
as?
some legally enforceable debt.
Sure.
If he has given me loan, my lord, he should show that this is the promissory note, this is the, for this I have, this is the proof that he has, I have taken loan from him. Because loan, my lord, without a promissory note, my lord, with interest, that is not legally enforceable. One person can say that this person has taken loan from me to 3 lakh or 10 lakh. But when it comes to legally enforceable, that means the court should recognize that this debt is enforceable, my lord. Right should be recognized and protected by the code of law. If the complainant says that I have taken a loan from him, he should show some promissory note so that the court may legally enforce that debt. If the liability under Negotiable Instruments Act 1881 is not absolute, my lordship. There are some restrictions, my lord.
What is a legally enforceable debt in the context of 138? Negotiable instruments.
No, Lord, 138 minutes. 138. These are a check for insufficiency, etc. of funds in the account. Page 41, the both page 41, 138. Where any check loan by particular account maintained by him.
Why are you reading this section? You tell us what is the legally enforceable debt in the context of section 138. You come prepared, Mr. Counsel.
First of all, my lord, BW he has submitted, he read over before your lordship, my lord, that already discarded because he did not appear for cross-examination. So that was not taken into account, my lord. So already, my lordship is well aware, my lord, revisional jurisdiction is very, my lord, limited.
He is trying to take argue before the court that it requires the revision is required, or for the powers on the 482 are required to secure the end of justice.
So what is the abuse of process? If somebody use a legal proceeding,
We'll
for
hear it.
legal purpose.
We are not closing it. We'll hear it. We'll. When would you be ready to argue, Mr. Counsel?
Otherwise,
3 days, my lord.
Any date other than today.
that 20% also not deposited till date, my lord.
We'll have it on 30. 30th of May.
30, my lord, no, 30, 31, I will be out of state.
Then on 6th of June. 6th of June.
Well, 119 and 139, the presumption of law. It is always presumption is in favor of the complainant against him, and or if he rebut it, then he has to present evidence. Money cloth case is there, our High Court case.
You come up with all the judgments in your favor.
Yes, madam.
Whatever you want to rely on. List on 6th of June for hearing as paid for by the brother councils for the parties. An attempt will be made to dispose of this revision petition on the next date fixed.
Fix the 2 item 10.
Yes, madam.
Once you may be creating for now.
The request of MS so list after a week.
One of the time in Timor and country. There is an
Interim order passed on 4/1/2021 will continue. List after which.
Time being item 25.
Yes.
Yes, my lord, I had gone through that diary, my lord.
Hmm.
So Ohidul statement is not there, but some other co-accused my lord arrested, their statement. Very, full time.
Who is Ohidul?
Ohidul statement is not there.
Who is Ohidul?
Ohidul, my lord, who rescued that girl, my lord.
Okay.
To other accused, my lord.
You call for updated CD then.
Updated case is already completed.
Almost up to date, but
7 time cases listed. 2
Hmm.
originals were sent for updated.
that two flag, my lord, horizontal flag, my lord, your lordship use.
But this person who's supposed to have rescued his statement is not here.
That is not recorded, my lord, by the
Yeah.
IO.
Earlier were 2 occasions sent at this diary for updated. Today is 7 time cases listed.
We'll give you an interim, let him get it updated. Heard Mr. Anuddin Leonard, counsel for the petitioner, and Mr. B.B. Goyal under DPP for the state. The case diary presented in pursuance to the earlier order of this court does not contain statements of certain witnesses for Mr. Leonard APP seeks time to complete his instructions. In the meantime, considering the fact that sufficient opportunities were granted to the state to call for updated CD, this court is of the view that in the meantime, if the petitioner is arrested, he shall be released on a bail bond, on furnishing a bail bond of rupees 25,000, with one local security of like amount to the satisfaction of the arresting authority. Petitioner, however, will be the interim bail granted will be subject to the following conditions. Number one, he shall appear before the IO within 10 days from today. He shall not attempt to influence or any person or witness connected with the state. He shall not impede with any documents in the course of the investigation, and he shall not move out of the jurisdiction of which police station is it? Moirabari.
Moirabari.
Without written permission of the IO. If any of the conditions are found to be violated, the IO will be at liberty to pray for cancellation of the bail, interim bail granted. The interim bail granted is subject to such orders as may be passed by the court upon perusal of the CD. Updated CD required to be presented by the court, by the learned APP, list on even date in July.
21st July.
The Monday, 21st, okay. 21st July.
June or July.
July.
I'm blessed. Supplementary list item 62.
Yes.
22nd of this month, matter of art. CD as well as medical report, my lord. Art, my lord. FIR, my lord, case. Assamese underground, my lord, case 13, my lord. And that's right. An allegation of my lord forcefully rape. Restaurant getting. Now, my lord, I'm coming to the case time. Maybe.
That
And my lord,
taking her to the restaurant.
Yes.
And medical
Why was it adjourned?
and medical report, my lord, we denied regarding forcefully death. Then my lord, petitioner is entitled to get the benefit of. And if medical report saying any injury, my lord. And my lord, main point, my lord, whether she made any evil and lawyer, nothing is there. So unbelievable, my lord, not trustworthy. That is. She has not stated why she could not raise noise. And it has also not alleged that the petitioner put his hand on her mouth. That is also not. So she did not get any
When was the incident alleged?
incident alleged on 19
Medical down
2023. If medical report saying any injury, so far allegation is concerned, forcefully there. Then I have nothing to say. The poor thing is delay is not matter. Actually, whether injury is there. Lordship, it is well known in all restaurants nowadays. CCTV is already been set up. And if the footage show any such allegation, and one thing is more important, my lord, is stop whether they examine or not. Because it is a public thing. And daytime. Allegation of time shown 1:30 PM. It is not a hotel, restaurant, cabin, the door is not shown. All cabin without having door.
Yes, Mr. Gogoi. 164 is there, but medical didn't say anything,
No injury.
no injury. Witness also,
Injury may not be there, my lord, because all are measured, my lord, there.
no, the allegation is of
Forceful.
forceful physical.
That is clear.
Forceful. Any
Which
condition-
forceful can be understood to be without consent.
But it is a open cabin, my lord.
No, that we do not know open cabin or my lord lock
No,
cabin.
in all restaurants, there is no, we all go in cabin.
All right,
No door.
we'll pass orders, yes. We'll pass orders. Let us go through it. We'll pass orders.
Proceed with, any condition, my lord.
We'll pass orders. We'll go through the case diary and pass orders.
Or may fix any other, date,
No,
if in doubt.
no doubts. We'll go through the
Because
case
Lordship,
diary.
my humble submission is that the why she made no any event. And
These are matters of trial, it will come
And-
in the trial,
and
when the charge sheet is filed.
and Lordship, without any noise,
Matter is still under investigation.
without any noise, and medical report does not say it.
That is correct. Medical report doesn't say it.
There is just if this type of allegation is accepted, then every prudent man will suffer. In daytime, in a restaurant, if someone lost their car after 2 or 3 days, but and staff has not reported anything. The manager also not corroborated, nothing is there. Nothing is there, Lord.
Any list
My lord,
orders?
my lord,
solitary witness, solitary evidence also sufficient, but whether trustworthy.
We'll go through it and pass an order. Mr. William,
Item 47,
we'll pass an order. Let us go through the city.
Any condition will file.
Yes, yes.
Hello.
Yes, madam.
What that is under 482. That was a notice was issued on 29/1/2020.
Hmm.
Ownership reflects that I have not taken steps. After issuance of notice, they dated 9/1/19 lordship. I have taken steps price. It is on 11/1/19. Thereafter, again, I have taken on 30/8/2019. Subsequently, I have taken another steps on 7/2/20 lordship. But in the
There's an office note on,
the office note lordship.
yes, it
Office
says,
note, it reflected that I have not taken steps as per order dated 3/2/20. But 7/2/20, I have taken steps lordship.
anyone has appeared?
Lordship, he should not. Till today, they have not decided. Earlier also, regarding this petition, I have filed an 482 application that was dismissed for default. But without passing the order on merit, the court cannot lordship pass order for dismiss of default lordship.
Which man, this matter?
This matter. So as I mentioned about and after hearing this. Hearing on 9/1/2019, notice was issued to it.
No, dismiss for default, which matter?
Earlier also, I have filed
Some other matter.
criminal petition regarding this matter, that was dismissed for default. And the second criminal revision. And there is an honorable apex court judgment also, the second application is also like.
All right, let us first clear the defect part. Learned counsel.
Project 3 is complaint case were pending in the in the court of judicial registry.
Very quick on the first step.
No, first, what has happened is there is an office note. So let us direct the registry to verify your, whatever you have submitted, that you have taken steps.
On 7th, I have given their.
No, correct, but the registry will have to verify and give a note that it has been received.
Previously also, Roshni, they have stated that we have not taken steps, but subsequently I have shown that I have taken step in logical court also, previously, in previous case also. Since 2011, they did not appear before the court.
You have taken steps thrice.
Twice. And after 3,
We'll direct it right now. Heard, MS M. Devi, M. Devi,
7/2.
learned counsel appearing for the petitioner. And also Mr. State is there.
Yes.
And Mr. B.V. Grover, learned APP appearing for the respondent number 1. Also, learned counsel for the petitioner submits that steps on respondent number 2 has been taken by the on 30/08/2019, 11/1/2019, 7/2/2020. Also, however, office note dated 11/5/2023 reflects the steps on respondent number 2. Fresh steps on respondent number 2 has not been received. You have taken fresh steps, or these are the original
Yes, sir. President. Yes, sir.
fresh steps.
And information of
Office to verify and make necessary endorsements as to the steps as to the submission made by the learned counsel, that steps have been effected on these 3 days. Let the matter be listed after 1 week,
Yes,
be listed after 1 week
it may be fixed.
with necessary endorsements made by the registry. List again on 8th of June, 8th of June.
48.
Take it as ready.
May I please Lordship, for N. Maharaj, I love different school and now.
At the request of MS, your name?
Kipshika Burwa, D Burwa.
D. Borwal, learned counsel appearing for the petitioner, matter stands adjourned for 2 weeks. As it is submitted that the arguing counsel is not available. List after 2 weeks.
49 and 50.
None appears for the petitioner on hold. Also, no steps for service of notice on respondent number 1 has also been taken as per office note dated 3/003/2023. List after 2 weeks.
51.
So in this case, we had like the friend has been API for the one customers. So in pursuance of this course, I have deposited the 50% of the trade amount and it is disbursed upon the revenue. They have duly received and acknowledged. I have received 50% worship. The service complete worship and NCR also received with your worship permit to fix it 8 worship for their.
This is for against the judgment for under NI.
Yes, worship. Both the courts decided in my paper.
All right. The learned counsel appearing for the petitioner submits that in terms of the court's order dated 22/11/2021, 50% of the check amount has been deposited before the trial court. And the same has also been withdrawn by the respondent as permitted by this court by the earlier order dated 22/11/2021. Mr. MS R. Chaudhary appears for the respondent number, sole respondent, is it?
No, worship. I am for 1 to 5 and private respondent and 2 is for state.
1 to 5. Mr. B. Gowai appears for respondent 6, the state of Assam. Since the council's parties are represented by the councils, let the matter be listed for admission in the month of June on a date to be fixed by the registry.
NCR both the courts.
LCR of both courts have already been received.
Apply.
52.
Yes, Mr. Das.
This is not complete. Is a complaint which we have filed a question of a complaint case. We are the Voltas Limited and others where they manufacture air conditioner. So ultimately we challenge this complaint before this court. Civil suit is pending. And my lord, we have been unnecessarily dragged in this particular FIR. I have no privity of contract. In the contract, privity of contract between the distributor, complainant and the distributor. Well, we are the manufacturer, we appoint distributor.
All right. Service
Yes.
as per office note,
Yes, sir.
dated 22/5/2023. Service is awaited
Yes.
on respondent number 2. List after 2 weeks. The interim order passed earlier will continue. There is an interim order.
Yeah, there is.
Interim order passed on 22/3/2023. Continued. Who's for the who are the respondents? Number 2.
State is there.
No. Respondent number 2.
Oh, respondent number 2.
Who is the respondent 2?
Complainant itself, my lord, Devki Nandan Agarwal.
They were the dealers.
We are the manufacturer, they are the dealers.
Respondent 2.
He's the buyer. He's a buyer, my lord, sorry.
Okay. And you are appearing for all the petitioners.
Yes.
Okay. Yes, list on. List after 2 weeks.
Yes.
On a date to be fixed by the registrar.
Did we operate?
53.
In this case, report from the Iowa point for regarding from the.
Any report received?
Not received, neither any report.
Office note dated 22/5/2023 reflects that
Scan copy of LCR also for neither. That is scan copy.
service on respondent 2 has not been received back.
Regarding service.
Have you filed? Dusty?
Yes, sir.
Yes.
That's it.
Have you filed Dusty?
Yes, sir. But he refused to accept the notice. In this regard, I am filing a video within 2 days.
That is what we are asking you. The learned counsel for the petitioner prays for a short date to file an affidavit to bring on record the status of service sought to be effected by Dusty mode on the respondent number 2. Full stop. Scan copy of the LCR call for has also not been received. Learned APP also submits that the report from the IO regarding the ownership of the vehicle, bearing registration number so and so has also not been received. List after 3 weeks.
But it may be.
Date will be fixed once you file your affidavit. You file your affidavit, date will come.
2 days, sir.
It will come.
Daily list for hearing item 54.
None appears for the petitioner involved. Mr. AM Dutt
Respondent to it.
appears for respondent number 2. And Mr. BB Gugoi appears for respondent number 1. List after a week.
Same matter item 55.
On behalf of Peter Manor, respondent number 2 has already appeared. Matter may come up for hearing.
Hearing. Yes?
Sir, I am here for respondent number 2 on behalf of Mr. Ayman.
No. You want to file any objections? You have entered appearance for the first time today.
My name is not the village person. I am on behalf of.
No, Mr. Hallo, has he entered appearance today or earlier?
Earlier, Lordship, as per office note 31, 31st 10/2019,
Hmm.
it appears, Lordship.
Matter is already admitted for hearing.
Yeah.
So let the matter be listed for hearing, as the same is already admitted for hearing by the order dated 23/1/2019, passed earlier by this court.
Interim order is there, interim will continue.
If it is there, it will continue.
Not okay.
Interim order passed earlier will continue until further orders.
Items 57, 58.
Yes,
Notice of
await service on respondent number 2 as per office note dated 2005/23.
Item 57 also aging order, extra order. Item 57.
50,
Correct.
interim order passed earlier will continue.